Hello, good afternoon everybody. Welcome to another video by me, Mr. Drone. This one, a little bit different, a little bit of a different setting. And it's because we know it's been reported that, or we don't know, it has been reported. This is all alleged and based on reports I'm going off in this video. But Burnley are suing Everton for £50 million. The clubs, Burnley and Everton, may not be meeting on the pitch until December this year in the Premier League, but the two clubs' legal representatives will be meeting this week at the International Dispute Resolution Centre, as Burnley have started their claim for £50 million in compensation from Everton. You will see me looking slightly to the left on this because over the past 24 hours I've made quite a lot of notes to put this video together. Educated notes and educated guess and predictions, I suppose, based on things that I already know a little bit about of. So, firstly, why the International Dispute Resolution Centre and not the usual county court or high court, even when it comes to a civil dispute like this compensation claim Burnley have issued? What is an International Dispute Resolution Centre? We'll look at first. So, an International Dispute Resolution Centre is a neutral, third-party institution that specialises in helping businesses from different countries resolve commercial disputes. Unlike going to the local courts, as I mentioned, High Court, Civil Court, for example, which can get messy, expensive and take years to sort out, these centres provide clear, reliable processes for sorting out cross-border disagreements quickly and fairly. So why the International Dispute Resolution? If the clubs only operated within the UK, it's easy to think the problems would be solved through familiar legal channels. But as soon as another country is involved, things can change. Like, for example, different legal systems. So the UK law versus the US law, for example, which one would apply? Which courts have authority? We know that both Everton and Burnley are owned by US owners, but they operate business within the UK and are therefore governed to an extent by UK law and, of course, the Premier League. Then there's international enforcement. Winning a decision in UK court doesn't mean that you'll get paid if the other side is based on, if the other party is based on the other side of the world. So when you win an award in court, you might receive your judgment award from the judge says you are owed £50 million, for example, by the other party, but the other party might not pay, and then you have to enforce that award. Enforcement becomes more difficult if you're enforcing in another country. That's a whole different story. I'm sorry if you can hear my watch going a bit mad. I'm getting notifications, but that's a different story about enforcement. If you want to know more on that, let me know. I may do a bit more. But anyway, that's another reason why to use international dispute resolution. It's aside from the different legal systems, the international enforcement, and then there's costs. International court battles are notoriously expensive and unpredictable, whereas the dispute resolution, as I mentioned above, can be clear, reliable, and resolved quickly and fairly. So how does an International Dispute Resolution Centre process work? So number one, the parties have to select the right centre and rules. Now, this is usually agreed between both parties up front. They decide which centre to use and which rules will govern any disagreements. Then there's number two, triggering a dispute. If a dispute crops up, one party or their lawyer will file a formal request to the chosen centre. The process typically includes setting out what's gone wrong and what outcome they want and paying a registration fee, which is usually less than the likes of the county court or high court fees, usually. Number three, they have to appoint an arbitrator or mediator. The centre either appoints an expert arbitrator or mediator or lets both parties pick someone from an approved list. The experts are trained in international law and commercial best practices. Then running the proceedings. So there's an official hearing in person or online for arbitration this is, where both sides present their evidence and arguments, just as you'd expect in a court case. The rules are usually simpler and more focused than in court too. Mediation or conciliation usually involves a private negotiation session where the mediator tries to help you both reach an agreement that both parties are happy with. But in this case, it seems to be arbitration. Number 5, then there's the decision and enforcement. So an arbitration award is legally binding and enforceable in most countries thanks to the New York Convention, which over 170 countries signed up to, including, of course, the UK. Mediated or conciliated settlements may be turned into binding agreements too, making them easier to enforce globally than informal deals. So the key features of international dispute resolution. What sets these apart from local courts? Neutrality. So there's no home court advantage at all. The centre and its experts are completely independent. Flexibility. Hearings can be held online in London or even in a country neither party is from. Language support. Most major centres work in English with translation available, but I don't think that would be an issue on this case anyway. The confidentiality. Unlike court cases, proceedings are usually private, protecting the sensitive business information and nature. Then there's the expertise. Arbitrators and mediators are commercial law experts, familiar with cross-border business realities. Okay, so that's about the International Dispute Resolution Centre, why we think it's being used as opposed to county court and civil proceedings. So we'll look at now a breakdown of the key issues regarding the claim that's gone in, that Burnley have made against Everton, or what I feel are the key issues. Okay, everything I'm saying here is based on my own findings and my own thoughts and feelings. None of this is factual, of course. I have to say that, but key issues. As we know, Burnley are suing Everton for £50 million, and the key issues are: 1, the Profit and Sustainability Rules, PSR. PSR stipulates that Premier League clubs cannot make a cumulative loss of more than £105 million over a 3-year period. These rules are meant to prevent clubs from overspending, especially on transfers and wages, in ways that could put them at risk of financial instability. Everton's financial losses, as we'll all know. Everton reported massive losses in the 2020 to 2023 period, which was far above the £105 million set by the PSR. However, Everton claimed these losses were mostly due to COVID-related impacts, matchday revenue drops, broadcasting issues, etc., and stadium development costs for our new home, Hill Dickinson Stadium. Although the Premier League allowed some leeway for pandemic-related losses, etc., there were concerns over whether this was being used to avoid sanctions. We all know this from the earlier report, but we'll just touch on it because this is what it's based on. The Premier League's Independent Commission determined that Everton incurred a loss of £124.5 million, exceeding the allowed threshold of £105 million. Everton were given a 10-point deduction for breaching PSR for the financial years ending 2021-22 before being reduced to 6 points after a successful appeal by Everton. Everton survived relegation by just 4 points in the 2021-2022 season, with the final relegation spot being taken by Burnley FC. That's the most important key factor. Burnley's complaint. Burnley were relegated from the Premier League in the 2021-22 season. They believed that Everton's financial mismanagement and breach of PSR gave Everton an unfair advantage in staying in the league. Burnley argue that the 6-point deduction handed out, had it been applied during the same season as the breach, Everton would have been relegated instead of Burnley. Again, another another key point. The basis of the claim there is that if Everton received the points deduction in the same season that they breached the PSR, Burnley are saying that would have dropped us 6 points and we'd have gone down, they'd have stayed up. Okay? So why are they claiming £50 million? Why 50 million? Burnley are seeking 50 million in damages, which they claim they lost out on due to the unfair advantage Everton had over them. This is likely tied to things like Premier League TV and sponsorship deals. Relegated clubs lose out on huge revenues that come with being in the top flight. We all know that. Then there's matchday revenue. The lower league also results in significantly reduced ticket sales, merchandise and other matchday income. Then commercial revenue. Being in the Premier League boosts a club's ability to sign lucrative sponsorship and partnership deals too. Everton's defence. Briefly, obviously, I don't know the full particulars of the claim Burnley have put in. Don't know the full particulars of Everton's defence. Again, going on kind of what I think. So it's likely, in my opinion, that Everton will argue that they operated within the Premier League's legal framework that existed at the time, and Everton accepted and served the penalties imposed upon them by the Premier League. For example, 10-point deduction reduced to 6 points. But is this good enough? So what I'm saying there is it a good enough defence for Everton to simply say, okay, we were found guilty, we admitted some, explained it. In fact, I think they admitted all of it, but just gave the reasons, gave the reasons as to why they ended up in that financial position, explaining them. And Everton are therefore saying, or therefore could say, we then received the penalties from the Premier League. That's not our fault that it wasn't given at the same time. We're not going to complain about it, of course. But is it Everton's fault? But is that good enough? So the case law, or the possible case law, I should say, is going to be based, or possibly based, entirely on a legal concept of loss of chance under a tort of negligence. Now bear with me. This is usually used to determine causation and assess damages in cases where the claimant, Burnley in this case, has lost the opportunity to pursue a course of action which they contend would have been pursued and had a chance of achieving some benefit. Loss of chance cases are assessed in 2 stages. The claimant, Burnley, is subject to the usual test on the question of whether the chance would have been taken in the first place. But for the breach, I will need to prove they would have taken the chance on the balance of probabilities. The balance of probabilities here is already proven, in my opinion, as Burnley would have stayed up if Everton would have deducted the 6 points in that season that Burnley went down, okay? However, always a however, the courts moved from this test when assessing the prospects of a claimant, Burnley, being successful in recovering a benefit against the third party, Everton. This is because the evidence required by the claimant to prove they will have secured some benefit is outside the claimant's knowledge and control. And the third party would have to speculate on the hypothetical outcome, which would have been dependent on a different set of facts. This is referred to as the counterfactual, in effect, predicting the past. So, if the court accepts the chance would have been taken by the claimant and the prospects of securing some benefit were real and substantial, but again, this is actually already proven, given the fact that Burnley would have stayed up in that 21-22 season if the points deduction was made in the same season. So, the case is proven that Burnley suffered a loss as a result of being relegated in that season. But does that make it Everton's fault? That is one of the fundamental questions, in my opinion. Does that make it Everton's fault? It's certainly Everton's fault for breaching PSR, as that's already been proven and admitted. But is it Everton's fault that it took the Premier League so long to make the decision and impose the points deduction. That's got to be a big part of the defence, really. But on that note, taking the other matters, what I've said about the law, it's if when you listen to the bits above, we also need to revisit the counterfactual concept, which is predicting the past. So if the points deduction was imposed during the 2021-2022 season, then that effectively changes the past on this concept. So how can it possibly be known what would have happened if that changed? So if Everton had the points deduction in that season, Everton may have then played with more desperation, possibly, and may have gained 4 more points. And on the flip side of that, Burnley or other clubs as well may have also played with a little less desperation, maybe, and picked up 4 or more less points. So you just can't know that. You just can't know that, and that's got to be a big issue of it. That on that basis, you just can't know what would have become, really, and you also have to prove that, really. Is it my fault? Sorry, the burden of proof is that. How is it Everton's fault? As I said before, how is it Everton's fault that the points deduction wasn't imposed at that time? Everton done, aside from breaching the rules, which was admitted, points deductions given. Everton then dealt with everything how they should have, I believe. We're led to believe anyway. They dealt with everything as they should have. So why now should Burnley be due even more compensation from Everton anyway? From Everton. So the question for me is, and I'm sure for maybe it is for Everton's defence, for a lot of Evertonians as well, maybe even Burnley fans, to be honest, and Burnley, maybe, I don't know. But why are Everton the liable party to Burnley? Should the claim not be against the Premier League for failing to impose a points deduction for the season as to when the breach occurred? Everton fans, myself, and Everton fans are, of course, happy that didn't happen. And couldn't have happened, I think, for the time the case went on for. But again, is that really Everton's fault for that? It just seems, to me, like a bit of desperation and mad claim for compensation. Where this probably come about is that I think the judge at the time presiding over the PSR claim, it was the judge or QC or whatever, actually did say that other teams may have a claim for compensation in relation to it, and looks like Burnley have jumped on that. Fair enough, why not? I just don't see, personally, I don't understand, I clearly don't understand every single case law, the in and outs of it all, but just trying to cover it as best as I can with my limited, to an extent, knowledge. I just don't quite get how Everton are a guilty and liable party on it. However, if it comes to the fact that they pass the test that Everton is a liable party and the claim can be made against Everton, then I don't see how Burnley then lose the claim, because it is the rest of it is proven. It's already proven that Burnley would have stayed up if the points deduction was given in the season where the PSR was made, it's already there. The figures are there. They finished 4 points behind us, and if we deducted 6 points, then there you go, we would have been gone. So yeah, it's going to be interesting. It's going to be interesting to see. But the one problem is that we might not ever see, because the thing is about the international dispute resolution centres is that, as we said, one of the key factors is confidentiality. Unlike court cases, proceedings are usually private, protecting the sensitive business information. So although we know it started, by now it may have finished, and we just won't know. Probably no point in making this video then. But I hope that covered some ground and some questions for some people. I hope so. Or did it raise more questions about international enforcement and stuff? I don't know. But yeah, let me know what you thought. As I say, be interesting. If we ever find out, it'll be interesting. But we may not ever find out what happened in this case. If there's a settlement, probably the likely outcome is some sort of settlement. If there's a settlement, then we probably won't know. Be a confidential settlement, and it'll disappear into the night like many other things. But yeah, I hope you enjoyed the video. Please like, share and subscribe. And before I go, mention this on every video now, I am doing Everton in the Community Sleep Out at Everton Stadium on the 10th of October 2025. If you would like to sponsor me, I'm trying to raise £500 for Everton in the Community and help the homeless. So if you could, the link's there. If you'd like to donate, thank you very much. If you've donated already, thank you so much. Yeah, take care, everybody. Please like, share, subscribe. Bye now.